Well, good afternoon, everyone, and thank you very much for joining us today. I'm delighted to see so many of you here, particularly since I understand there may be travel difficulties later on, if not at the moment. As Undine mentioned, I am joined by Sheriff David Harvie and Sheriff Louise Arrol KC, both former members of the Council, and both of whom I will introduce formally later on ahead of their respective presentations. The level of interest in this event is very encouraging from the Council's point of view, but also a sign of the importance of the subject matter. This is, of course, our sentencing guideline on the statutory offences of causing death by driving, which was approved by the High Court in October and came into effect today. Some of you may never deal with cases like this in your careers, but I think the webinar will nonetheless be of value by explaining the nature and effects of guidelines, many more of which, covering a broad range of offences, will come into force in the years ahead. I'm going to give a brief overview of the development and aims of the Death by Driving Guideline, but before that I want to set out some background about the Scottish Sentencing Council and its work to date. The Council is an independent advisory body which was established in 2015 as a result of the Criminal Justice and Licensing Scotland Act 2010. It has three statutory objectives. Firstly, to promote consistency in sentencing practice. Secondly, to assist the development of policy in relation to sentencing. And thirdly, to promote greater awareness and understanding of sentencing policy and practice. Our functions include preparing sentencing guidelines for the Scottish courts, publishing guideline judgments issued by the Scottish courts, and publishing information about sentences imposed by the courts. In respect of sentencing guidelines, the 2010 Act provides for these to cover a broad range of matters, including the principles and purposes of sentencing, sentencing levels, and the particular types of sentence that are appropriate for particular types of offence or offender. The Council describes the guidelines it prepares as general guidelines and offence guidelines. Guidelines must be approved by the High Court before they can take effect. When sentencing an offender, a court must have regard to any sentencing guidelines which are applicable to the case. A court can decide not to follow a guideline, but it must state the reasons for its decision. To date, the Council has finalised and the High Court has approved three general guidelines which provide a high-level framework for sentencing in Scotland. These are Principles and Purposes of Sentencing, which came into effect in November 2018, the Sentencing Process, which came into effect in September 2021, and Sentencing Young People, which came into effect in January 2022. Sheriff Harvie will say more about these general guidelines later on, but once they were finalised, the Council turned its full focus to the development of offence guidelines, which is to say, guidelines to help courts select a specific type and level of sentence for a particular offence or group of offences. So why did we decide that our first offence guideline should cover death by driving offences? From an early stage in the Council's work, sentencers told us that they face particular challenges in sentencing death by driving cases. These circumstances are often highly complex and can vary significantly between cases. In particular, there can be a large discrepancy between the harm caused, someone's death, and the culpability of the offender. This is particularly so in careless driving cases where the offence may result from a momentary lapse in attention or single error of judgment by a person who has never been in trouble with the law before. These challenges are compounded by the fact that there are comparatively few death by driving cases, meaning that sentencers may be less familiar with the particular issues that arise in sentencing such cases. Alongside this, death by driving cases are of significant public concern. They have a devastating effect on the families of victims and others affected by the offence. It is also, as our research has shown, a lack of public understanding and awareness of the law and sentencing practice in relation to death by driving offences, the difference between dangerous and careless driving, and the full range of factors taken into account by the courts. All in all, death by driving cases are amongst the most serious, complex and sensitive to be dealt with by the courts. Having considered all of this, we concluded that a guideline on death by driving offences would bring significant benefits to the public and to the courts. Preparation of the guideline followed the Council's 8-stage development process. This was designed to ensure a robust, evidence-based approach. We are sometimes asked about the pace of guideline development. Let me say something about that. Gathering and analysing statistical data, meeting and engaging with key stakeholders both in Scotland and beyond, commissioning and evaluating independent research, preparing and testing draft guidelines, consulting the Lord Justice General and Lord Advocate, holding a full-scale public consultation exercise, taking all of this and more into account when finalising a guideline for submission to the High Court. Each of these steps takes considerable time, effort and resources. Bear in mind that the Council is developing multiple guidelines at any one time. This means that preparing a guideline is a multi-year exercise, similar in many respects to the development of legislation. We have to take the time to get it right. For the death by driving guideline, we engaged with a wide range of individuals and organisations during the drafting process. This included the judiciary, legal profession, criminal justice bodies, sentencing advisory bodies in other jurisdictions, and other key stakeholders. Alongside this, we carried out a detailed statistical analysis of sentences imposed for death by driving offences over a number of years. We also commissioned a number of research projects, including a report which explores the views of family members of victims of death by driving offences, and a nationally representative survey of public attitudes to sentencing in Scotland, which included scenarios on death by driving offences. A key stage was the public consultation on a draft of the guideline in 2022. This was anything but a rubber stamping exercise. It was vital in ensuring the guideline will be fit for purpose. Each response was carefully considered as part of an independent analysis, and aspects of the guideline were changed as a direct result of issues raised or suggestions made by respondents. Particularly aggressive driving was included in the highest level of seriousness alongside racing. The list of aggravating factors was expanded. Some of the sentencing ranges were increased, and driver inexperience was removed as a mitigating factor for all offences apart from causing death by careless driving. We have published a very thorough report about the consultation which explains all of our decisions about the guideline in detail. The Council also has a statutory duty to provide an assessment of the costs and benefits to which the implementation of any of its guidelines is likely to give rise, and of the likely impact of a guideline on the criminal justice system in general. We have not encountered any evidence of systematic inconsistency in current sentencing practice for death by driving offences in Scotland. The guideline is intended to reflect current practice, and we do not anticipate systemic changes to sentencing outcomes as a result of its introduction. What then are the aims of the guideline? It is intended to help sentencers and practitioners by listing some of the key features relevant to the assessment of the offender's level of culpability and the seriousness of the offence, setting out aggravating and mitigating factors, providing sentencing ranges, and preserving the flexibility and discretion required in the sentencing exercise. It will help to promote public understanding by improving awareness of the law and practice as it relates to sentencing for these offences, improving understanding of the complex issues involved in the sentencing exercise, aiding with the predictability of sentencing for accused and convicted persons, as well as victims' families, and explaining how sentencing decisions are made and why. While nothing can make up for the tragic loss of life involved, the Council also believes that the guideline will provide clarity for bereaved families and others affected by death by driving cases. I'm now going to hand over to Sheriff Harvie, who will discuss how the guideline covers the assessment of seriousness. Before becoming a member of the judiciary in 2022, Sheriff Harvie worked for the Crown Office and Procurator Fiscal Service, which he joined in 1996, following a spell in private practice as a solicitor advocate. During his career with COPFS, he held various senior positions before becoming Crown Agent in April 2016. As Crown Agent, he was the Scottish Sentencing Council's prosecutor member between 2016 and 2021, a member of its Sentencing Young People Committee, and chair of its Death by Driving Committee when most of the heavy lifting was done. He has been involved in the development of all 4 of the Council's approved guidelines and remains an advisor to the Death by Driving Committee by invitation of the Council. Sheriff Harvie.
Thank you, Lord Matthews, and good afternoon, everyone. I would like to echo what Lord Matthews has said about the complex and tragic nature of death by driving offences. I understand how fraught these cases are for all concerned, particularly from my time as a prosecutor. This was at the forefront of the minds of those of us involved in the development of the guideline, which was a task none of us have taken lightly. I'm going to speak about the assessment of seriousness of death of driving offences, which will involve a brief outline of the statutory offences covered in the guideline, before going on to discuss how it sets out levels of culpability and features of seriousness. But before that, I want to cover an important issue: the interaction between different guidelines. In addition to the changes to the guideline outlined by Lord Matthews as a result of the public consultation, we also took account of responses which suggested that the relationship between the Death by Driving guideline and the 3 general guidelines was insufficiently clear. To address this, the how to use this guideline section was significantly expanded in order, firstly, to reflect all of the steps in the sentencing process, secondly, to highlight the approved guidelines section of the Council's website, to make readers aware of any other guidelines that may apply to the case, and third, to make it clear that the guideline should be used to arrive at the headline sentence for the offence under consideration, but importantly, that the final sentence may differ as a result of other applicable guidelines or matters such as timing of a guilty plea. To explore this further, I'll say a bit more about the 3 general guidelines. The first 2 of these, principles and purposes of sentencing and the sentencing process, apply to all cases and every sentencing decision. The third, sentencing young people, applies to all offences, including death by driving offences, but only in cases where the person being sentenced is a young person, as defined in that guideline, so it's more limited in its applicability. This means there's no such thing as a standalone guideline, as there will always be at least 2 guidelines that apply in any single case. The Principles and Purposes of Sentencing Guideline sets out the core principles that sentences in Scotland must be fair and proportionate. Among other things, this requires that all relevant factors of a case must be considered, including the seriousness of the offence, the impact on the victim and others affected by the case, and the circumstances of the offender. And that second, sentences should be no more severe than is necessary to achieve the appropriate purposes of sentencing in each case. The purpose that a sentence may seek to achieve, there's a list of those. Protection of the public, which includes the deterring of offending behaviour, punishment, rehabilitation, giving the offender the opportunity to make amends, and expressing disapproval of offending behaviour. The Sentencing Process Guideline sets out an 8-step process explaining how courts arrive at sentencing decisions and the factors which may be taken into account. This includes how courts should assess the seriousness of an offence with regard to the culpability of the offender and the harm caused, including the impact on any victim and consideration of aggravating and mitigating factors. Because the principles and purposes of sentencing and sentencing process guidelines are of universal application, they contain foundational elements which do not need to be repeated in every offence guideline, making offence guidelines more concise, simpler to understand, and easier to use. But this means that the two general guidelines must be read alongside offence guidelines. So too must the Sentencing Young People Guideline, but only where the person being sentenced is aged 24 or under at the time of a plea or at the time finding of guilt. This guideline is based on robust, independently assessed evidence from around the world into the factors that contribute to offending by young people and what is effective in reducing reoffending. It states that rehabilitation is a primary consideration when sentencing a young person because young people generally have a greater capacity for change. However, it makes clear that the full range of sentencing options remains open to the court, including a custodial sentence. I think it's important to pause here in order to emphasise the interaction of different applicable guidelines before we focus on the death by driving guideline. I'd like to give you an example to illustrate why. As someone who was a member of the Council's Sentencing Young People Committee, I was struck by how coverage of the Sentencing Young People Guidelines sometimes creates the impression that it was the only guideline that applied in a case and that it overrode all other considerations, such as the harm caused to victims. What is missed here is the applicability of the sentencing process guideline to the sentencing of a young person. As the Sentencing Young People Guideline makes clear, it does not affect the court's consideration of the level of harm. Detailed guidance on the assessment of harm is set out at paragraphs 12 to 16 of the Sentencing Process Guideline. It is very important not to lose sight of that. It will always be for the sentencer to decide exactly how to apply the relevant sentencing guidelines in any given case. But in respect of the interaction between the Sentencing Young People Guideline and the Death by Driving Guideline, it may be worth noting that the High Court stated recently in the case of Dunn versus HMA that the assessment of culpability for a young person does not involve a mere discounting exercise of an arithmetical nature. Correct approach, in our opinion, in the court's opinion, is to assess the seriousness of the offence, having regard to the level of culpability and the harm. With that necessary context provided, I'll turn fully to the Death by Driving Guideline. For completeness, the guideline covers the following offences under the Road Traffic Act 1988. Section 1, causing death by dangerous driving. Section 3A, causing death by careless driving when under the influence of drink or drugs. Section 2B, causing death by careless or inconsiderate driving. Section 3ZB, causing death by driving while unlicensed or uninsured. And Section 3ZC, causing death by driving while disqualified. The offences are listed in descending order of the maximum sentence provided by law, with the infrequently prosecuted offences under Sections 3ZB and 3ZC at the end of the guideline. The first thing to say about assessing the seriousness of these offences is that the level of harm, someone's death, has been fixed by law. The seriousness of the offence is therefore largely determined by the level of culpability of the offender. Aside from this, there are significant differences between these offences, not only because differing statutory maximum sentences apply, but also because the circumstances and levels of culpability will vary considerably. And while the standard of driving is a key part of assessing the seriousness of Section 1 and Section 2B offences, for Section 3A, the level of intoxication is also part of that assessment, while for Section 3ZB and 3ZC offences, the level of culpability results primarily from the fact that the offence occurred when the offender was not allowed to drive. For every offence covered by the guideline, tables are provided at each of the first 3 steps. At step 1, they list features to help the sentencer determine the level of seriousness. At step 2, they set out sentencing ranges for each level of seriousness. And at step 3, they list aggravating and mitigating factors which may make the offence more or less serious and move it out of the range identified at step 2. This leads the sentencer to step 4, determination of the headline sentence. The remaining steps 5 to 8 are explained in the sentencing process guideline. Sheriff Arrol will cover steps 2 to 4 and 5 to 8 later. I'm going to focus on step 1, mainly in respect of the offences of causing death by dangerous driving and causing death by careless or inconsiderate driving. This is because Section 3A, 3ZB and 3ZC offences are very rare. In preparing the impact assessment on the guideline, we discovered that between 2011 and 2021, they were disposed of fewer than 10 times. For causing death by dangerous driving, then, the court should determine which level of seriousness, A, B or C, with A being the most serious, the case before it falls into, having regard to the features listed at page 5 of the guideline, or to any other features which the court considers relevant to its assessment of seriousness. The guideline states that where multiple features from level B or C are present, it may indicate that the case should be assessed as having a higher level of seriousness. There were suggestions in the consultation that there should be only 2 levels of seriousness, A and B, with some feeling that the behaviour outlined in level C is not any less culpable than that in level B. We decided against this, as we felt that reducing to 2 levels would limit the ability of sentencers to differentiate between cases. It would also mean wider sentencing ranges, which might increase the potential for inconsistency or unintended increases in sentencing levels. There may be a fine distinction between some of the features in levels B and C, but that's perhaps an inherent characteristic of death by driving offences. There's a full explanation in the consultation report of the Council's decisions in relation to the features of seriousness for Section 1 offences, so I don't intend to cover that here. But I do want to emphasise, however, that the guideline is not intended to cover every circumstance. Indeed, it would not be practicable or possible to do so. We have tried to list what appeared to us to be the most important features of seriousness. But just because something is not listed does not, of course, mean that it would not or should not be considered. One of the reasons we have included the headings nature or manner of driving, capacity of driving, and other in the table is to indicate the general categories that features not mentioned in the guideline may fall into. The additional context the headings provide may also be helpful for public understanding of what the court is taking into consideration, as well as being able to help some sentencers. Headings are also used in the aggravating and mitigating factors tables for similar reasons. For causing death by careless or inconsiderate driving, the 3 levels of seriousness only have a single feature. Level A is careless or inconsiderate driving, which falls not far short of dangerous driving. Level B is careless or inconsiderate driving, which does not fall into level A or C. and level C is careless or inconsiderate driving arising from momentary inattention. We found it easier to define these offences either by saying what they are not, or at a high level, rather than to try to set out specific types of circumstance that they may involve. These are, in a guideline covering complex and sensitive issues, perhaps the most challenging of all to deal with for all concerned. I want to close by briefly covering sections 3ZB and 3ZC offences. Although section 3ZB causing death by driving, unlicensed or uninsured drivers, and section 3ZC causing death by driving, disqualified drivers, are separate offences with different maximum sentences in law, they are addressed in the same section of the guideline due to certain similarities between them. They were in fact all previously under section 3ZB before an amendment as a result of the Criminal Justice and Courts Act 2015 removed the disqualified driving part into a new section 3ZC. As I've mentioned, both are very rarely prosecuted and current sentencing practice cannot be established for them. The level of culpability in both offences is not determined by the standard of driving. It results from the fact that the offence occurred when the offender was not allowed to drive. Our decision to deal with them side by side in the guideline, rather than separately, was informed by the judgment of the UK Supreme Court in Harvie Hughes, in which the court ruled that the standard for section 3ZB requires, and I quote, some element of fault, whether amounting to careless, inconsiderate driving or not, and which contributes in some more than minimal way to the death. This was approved and followed in the Scottish case of Stewart v HMLA, in which the appeal court said, it is a decision to which high regard should be paid. I think this webinar could have focused solely on the issue of assessing the seriousness of death by driving offences, but there would still have been far more that could be said. But I do hope this overview has been helpful in explaining some of the complexity of the issue and how the guideline deals with it. I'll hand you back to Lord Matthews and thank you for your attention.
Thank you very much, Sheriff Harvie. I'm now pleased to introduce, if that's the right word, I'm sure most of you know her, Sheriff Louise Arrol, KC, who will speak about the determination of the headline sentence. Sheriff Arrol was admitted to the Faculty of Advocates in 2005 and is a graduate of the University of Dundee. Before calling to the bar, she was a solicitor for 8 years, prosecuting and defending in the criminal courts at both Solemn and summary level. Since 2005, and before becoming a member of the judiciary, she appeared almost exclusively in the High Court conducting criminal trials and criminal appeals, and also held an ad hoc commission as an advocate depute. She was appointed King's Counsel in October 2022 and became a sheriff in September 2023. She was the Scottish Sentencing Council's advocate member between 2022 and 2023. She was also a member of the Council's Death by Driving, Research and Sexual Offences Committees. Sheriff Arrol.
Thank you very much, Lord Matthews, and thank you also to Sheriff Harvie, and good evening to all of the participants. As Sheriff Harvie has said, I am going to discuss steps 2 to 4 in the guideline, which covers selection of the sentencing ranges, aggravating and mitigating factors, and determining the headline sentence. One of the key decisions that the Council made in finalising the guideline was not to include starting points in the sentencing ranges. For those who may not know, starting points are a suggested sentence within a range from which the sentencer will start before adjusting it for seriousness and any aggravating or mitigating factors. These are a common feature in sentencing guidelines in other jurisdictions. The Council gave the arguments for and against inclusion of starting points very careful consideration. In the end, it was agreed that starting points should not be included in the guideline. Each case involves a unique set of facts and circumstances. What might be a suitable starting point for one case might well not be appropriate for another. Starting points would be the equivalent to saying that there is an average or standard sentence for these offences, but the Council does not believe this to be so. The court must consider the specific nature and details of the case before it, taking a careful, individualised approach in line with the principles and purposes of sentencing and the sentencing process guidelines which Sheriff Harvie spoke of earlier. Accordingly, the death by driving guideline leads the court to an appropriate range for the seriousness of the offence before it. In the Council's view, the court is better placed to determine where exactly within that range the starting point sits. The Council felt there were other issues which militated against starting points. For example, the High Court does not generally set out starting points in its opinions about sentence appeals in Scotland. Starting points also would not necessarily assist public understanding or provide greater predictability about the sentence likely to be imposed. A clear distinction cannot be drawn between starting points and sentencing ranges in this context. Both simply indicate a possible sentence that may be adjusted once aggravating and mitigating factors and other matters are taken into account. These are things that, for example, families and members of the public would not necessarily know about in advance. The relatively narrow ranges in the guideline might make the usefulness of starting points questionable. They would also reduce the scope for the court to tailor the sentence to the specific circumstances of the case. Finally, as Lord Matthews has noted, the Council has not encountered any evidence of systematic inconsistency in current sentencing practice for death by driving offences in Scotland. It therefore does not believe that the guideline will introduce inconsistency simply by lacking starting points, particularly as the sentencing ranges it sets out reflect current sentencing practice. Moving on to sentencing ranges. The first thing I want to say is that different maximum sentences are set out in law for these offences due to the differing levels of seriousness. The guideline lists the maximum sentences, which are life imprisonment for Section 1 and Section 3A offences, 5 years imprisonment or detention for Section 2A offences, 2 years imprisonment for Section 3ZB offences, and 10 years imprisonment for Section 3ZC offences. The statutory maxima are not included in any of the sentencing ranges, but it remains open to the court to impose the maximum sentence where it considers this the most appropriate sentence. The guideline does not prevent this. The Council's view is that the maximum sentences are likely to be considered only for cases that are so serious as to be out of the norm and rare enough that they do not need to be detailed within the guideline. Of course, it may also be open to the Crown to prosecute drivers in such cases for murder or culpable homicide, depending on the circumstances. Additionally, including the maximum available sentence within ranges may not give sentencers sufficient guidance as to the appropriate sentence, which could limit the guideline's usefulness, especially in terms of consistency and predictability. The Council based the sentencing ranges in the guideline on a very careful and detailed analysis of sentences imposed by Scottish courts for death by driving offences over a number of years. This included seeking the views of judges who've imposed them and examining the sentences with regard to sentencing practice more generally. Of particular relevance was the High Court's practice when sentencing other offences which result in a fatality, such as murder and culpable homicide. As a result, the sentencing ranges reflect the upper limits of sentences which have been actually imposed by Scottish courts for each offence covered by the guideline. For example, the highest point of the sentencing range for causing death by dangerous driving, the most serious of these offences, is 12 years imprisonment. This is the longest term of imprisonment we are aware of that has been imposed for a Section 1 offence in recent years. The most common headline sentence for Section 1 offences are between 2 and 6 years. Very few cases of causing death by careless or inconsiderate driving result in a custodial sentence at all, and we are not aware of any recent cases in which the statutory maximum has been approached. We expect that circumstances which would attract a penalty beyond the range set out in the guideline for these offences would likely be prosecuted either as death by dangerous driving instead, or with an alternative death by dangerous driving charge, meaning that the driver could be convicted of either causing death by careless driving or causing death by dangerous driving. Offences under 3A, 3ZB and 3ZC, as Sheriff Harvie has already noted, are very rare. So the Council could not establish current sentencing practice for them. The ranges for the most serious offences involving driving under the influence of drink or drugs reflect those for death by dangerous driving. Although the standard of driving will generally be lower, the level of intoxication increases the level of culpability. Offences involving driving while unlicensed, uninsured, or disqualified are likely to attract sentences similar to those for causing death by careless driving. So the ranges reflect those set for that offence. In practice, the Council expects that such cases would likely be prosecuted as death by dangerous driving instead, where the standard of driving is so bad that a sentence above the highest ranges in the guideline would be warranted. I want to turn now to step 3, which concerns the identification of aggravating and mitigating factors. For each offence, there is a table which contains a non-exhaustive list of, to quote the guideline, additional factual elements, which may apply to the offence and the offender. It is important to note what the guideline says here, which is repeated for each offence. The court shall consider which of these factors apply, together with any other factors which, in the view of the court, aggravate or mitigate the offence or sentence. In some cases, this may move the headline sentence outside the range selected at step 2. The point about the headline sentence moving outside the range selected at step 2 is significant, because it shows that the guideline allows sentencers flexibility and discretion. They are not rigidly bound to remain within a selected range and can select a sentence that goes above the top or below the bottom of a range, where this is considered appropriate in the circumstances of the case. In terms of the actual aggravating and mitigating factors listed, I want to make you aware of a couple of important points. First, the factors listed in the guideline are those the Council considered most relevant to death by driving offences. Other factors which may be relevant are contained in the Sentencing Process Guideline, which lists some examples of statutory aggravations, as well as examples of possible aggravating and mitigating factors. Second, while the tables of aggravating and mitigating factors in the Death by Driving Guideline are broadly similar for each offence, they are not all identical, and there are some important differences. For example, the offence being committed during pursuit by the police is an aggravating factor only for causing death by dangerous driving, while driver inexperience is a mitigating factor only for causing death by careless or inconsiderate driving. The consultation report discusses aggravating and mitigating factors in detail, so I refer you to that for more detail, but there are a couple of issues that I will mention here. The victim being a vulnerable road user, for example, a pedestrian, cyclist, horse rider or motorcyclist, is included as an aggravating factor for all offences. This reflects the hierarchy of road users as outlined in the Highway Code. A related issue the Council considered was whether the driving of larger vehicles such as HGVs should be treated as an aggravating factor. This was carefully considered but ultimately rejected. The Council felt that it created a risk of unduly holding drivers of larger vehicles to a higher standard of driving, and that the features of seriousness outlined in the guideline are sufficient to cover the possibility that driving a particular vehicle in a particular way may have consequences. The other issue is a particularly fraught one. It was suggested in the consultation that more than one person killed should not be considered as an aggravating factor, as more than one death entails greater harm. It should instead be considered as part of the assessment of seriousness and listed at the most serious level. Again, the Council considered this very carefully. In cases which may involve broadly the same features and a very similar standard of driving, a different number of deaths could result due to other circumstances, such as the number of passengers in one of the vehicles involved in the collision. Including multiple fatalities as a feature of seriousness might result in a case being assessed at a higher level of seriousness than one where the culpability of the driver was of a similar nature, and receiving ultimately a disproportionately higher sentence. For this reason, more than one death remains as a factor which aggravates the offence at step 3, rather being a determinant of seriousness at step 1. But the court can still increase the sentence, including by selecting a sentence in a higher range if it considers this to be appropriate. Having gone through steps 1 to 3 then, the court will reach step 4, where it determines the headline sentence. This is the sentence selected by the court, which takes into account the seriousness of the offence and any aggravating and mitigating factors. This is as far as the guideline goes. Where there are no other relevant matters to consider, this sentence may be the final sentence, which the court can proceed to impose in line with step 8 of the sentencing process guideline. But there may of course be a need to adjust the sentence to take account of a discount for a plea of guilty at an early stage in the case, which is covered at step 5 of the process guideline, or any time the offender has spent in custody, which is covered at step 6. Step 7 requires the court to consider any ancillary orders, which are orders imposed by the court in addition to a sentence or, in some instances, as an alternative to the sentence which the court could have imposed. So again, we see the need to be aware of the provisions of the General Process Guideline. And I hope it goes without saying that there are a range of matters beyond guidelines that courts must have regard to when deciding a sentence, such as the sentencing powers open to them depending on which court the case is heard in, and any guideline judgments issued by the High Court or Sheriff Appeal Court, or, depending on the circumstances, the restrictions on passing custodial sentences where the offender is under 21, is over 21 but has not served a custodial sentence before, or where the sentence is likely to be 12 months or less. I hope this has given you a helpful walkthrough of Scotland's first offence guideline. This will set something of a precedent for future offence guidelines. However, as has been noted, because the level of harm in death by driving offences is fixed by law, this guideline does not entirely fit the culpability harm model, unlike many other offences. As a former member of the Council's Sexual Offences Committee, I personally was involved in the early development of guidelines on rape, sexual assault, and offences involving indecent images of children. And I can say that each of these guidelines presents distinct issues and challenges. As far as the Council's offence guidelines are concerned, I think it is safe to say that one size doesn't necessarily fit all.
Thank you very much, Sheriff Arrol. Can everybody hear me? Excellent. The purpose of this webinar was to raise awareness of the Death by Driving guideline, which is required under Stage 7 of the Council's guideline development process. Stage 8 concerns the monitoring and review of in-force guidelines. This is something the Council has a statutory obligation to undertake. We have a staged process for this. In the first year of a guideline's operation, we monitor its application via sentencing statements, media reports, internal court documents, recording decisions not to follow or to depart from guidelines, and where appropriate, engagement with sentencers. We are now entering a period of review in respect to the Death by Driving guideline, just as happened with the Sentencing Young People guideline. I might in fact take this opportunity to clear up any misconception that the Sentencing Young People guideline is under review due to any concern around its operation. That is very far from the case. It is simply a routine exercise in accordance with the Council's published methodology for guideline monitoring and review. That concludes the presentations. We're now going to move to question and answers, and to facilitate free and open discussion of the questions posed, we'll switch off the recording and I'll pass you back to Ondine.